Ojha, coming to the contextual risk mitigation, what is force majeure and how it is to be treated in contractual relationships?
Thank you, Dr. Sirohi. That's a very important and a pertinent question, which is today confronting the industry, confronting the legal circles, the courts, and everyone. So I think it's a very, very relevant aspect that you have raised. And I welcome everyone to this discussion. It's a wonderful initiative by IISc, and we all wish you that you remain safe in these times. Dr. Sirohi, it's a very wide topic. It's a very varied topic, diverse topic in itself. But we will try and cover some ground today within the time that we have to make some logical, conclusions and try and get some clarity for our friends on this aspect. Now, I would like to share my screen with you so that what we talk, you get the structure of what I'm going to discuss today, and within that it will be easier for us to cover these topics. So 1 minute, I will just share my screen with you. Yes. Now, yes. So today, in response to this question, I would touch 5 aspects with you. One is conceptually, what is force majeure? There has not been a lot of discussion around it, but it's very important to understand it as a concept. Second, what are the features, the broad aspects of force majeure which needs to be looked at? Then we take it into the contractual paradigm, and obviously the moment we step there, we find 2 categories. A situation where your contract provides for a force majeure clause and provisions, and another situation where there is no provision of contract in your force majeure. It's simply silent. It leaves us to guess and understand what it means. And in that context, I will also touch on the features of frustration of contract and what is frustration of contract legally and what is not. And finally, I'll try to sum it up in some kind of overall conclusions for you to give a telescope view of what I have spoken. So that's going to be the framework in which we will talk. Now, coming to the first of all, the premise in which I'm going to talk today, there are 2-3 aspects which I would straight away lay out upfront so that these do not bother us. First is that we all recognize and we realize that there is very limited direct jurisprudence or law, nationally as well as internationally, as to how force majeure clauses have operated in the context of epidemic or pandemic. So while we do have the concept of force majeure in various instances and various situations, but how these have run their course, how these have been interpreted, how these have been seen in the context of a pandemic as we are facing today, there is very limited law or jurisprudence. So in that sense, this law is also evolving as we talk about it, and it is novel in nature. So what we have to do now, if we do not have a direct law, you delve into the general jurisprudence of how force majeure works and try to extrapolate that or reflect it to the present situation. That's what we will try and attempt to do. Another premise which you have to keep in mind is that what I say today is based on our expertise on the subject and our practical experience, how we have seen it nationally as well as globally. I have been involved in these kind of matters, both in the drafting and the adjudication space in India and outside. So a lot of what I say will be drawn from that experience and expertise. Finally, whatever I talk about, there is an underlying legal basis. and there is underlying legal rationale, jurisprudence to what I say. Today, within the limited time, we cannot go into those details as to which was the case, which court said it, how it has evolved. Maybe at a much more focused forum, or at a individually at some level we can get into that. But you can rest assured that what we say has legal and judicial basis. Now, with that premise, let me take the first point. What is force majeure? We have heard about it, we have read about it generally and specifically in the last 2 months. In simple terms, the word means superior force. So it's an external force, it's a superior force which has come into being, which is now being seen in the context of the existing contractual relationship. Now, when you take this superior force in the domain of contracts, the effect of the superior force is that it has altered parties' obligations and liabilities under the contract. So this superior force has changed the way parties would be able to or are capable of performing their obligations and liabilities under the contract. So that's what the concept of force majeure you have to keep in mind. Now, the second aspect, as I said, was what are the features of force majeure? There are many individual set of facts, set of conditions, guiding law, governing laws, and across this varied spectrum of the judicial pronouncement and the jurisprudence, there are some features which are common, which I will try to put it to you. First of all, we are very clear that it's a creature of contract and not the general law. That means, except for certain countries where it is also codified in their law, force majeure emanates, it operates within the realm of contract. Being so, when we get this concept into Indian law, it doesn't have a precise legal technical meaning. So you would not typically find a statute or a law which has defined force majeure. So it's not codified in that sense. But indeed, we have a very wealthy kind of a compilation of judicial precedents, and they are very seminal, and they have described, they have discussed, they have tried to unfold for us as to what force majeure means. Naturally, there is more jurisprudence in the international law than it is in India, but India also has some very similar judgments on this. Now, you have to be very clear that just because it doesn't have a technical meaning or not codified, it doesn't mean that it will not be enforced by the country or the laws of the country or the governing law of the contract. It will be enforced, but it will be enforced within the four corners of your contract. So there is a enforcement paradigm to this. You can actually go ahead and seek your solutions and remedies. But while you do that, you have to bear in mind that law does not automatically apply force majeure to the principles of contract. So it's not that law is there, you straight away go and take the course. But it applies based on your contractual covenants, the contractual provisions which you have. So in that sense, your contractual covenants are really the bridge through which the law will approach your situation. Finally, another feature that we find is that the legal principles of mitigation are applicable. That means today, in common parlance, it means that whatever you can do to reduce the risk or the damage of the other party, you should be doing as a reasonable contracting party. Practically, there are examples now of government policies, relaxations, some kind of aid or support or whatever is being announced. Now, these are the kind of factors which impact mitigation. So they will have to be read into the contract. You will have to take those steps. Now, with that, we are clear of the force majeure and its features. Now, as I mentioned, that we discuss this generally in two categories. If your contract has a provision or it does not have a provision. So if you pick up the first category, that if your contract does provide a force majeure clause, then your starting position will be that you check your precise definition of force majeure in the contract. How is it defined? In our experience, we have rarely found unqualified definitions in contracts. It always says what will constitute force majeure and has some kind of a description. Read that. Also see that how does your contract allocate the overall risk between the parties. Is it a contract where the payment is scheduled towards the end? It is upfront payment backed by guarantees, whatever. So assess the overall risk between the parties in the contract. Then very important that you have to then examine, remind yourself of the pre-contractual circumstances. That means what was the legal, practical, commercial reality or the ecosystem in which you entered into the contract when you executed the contract. And with that, you have to contrast it with the impending situation that has arisen. So there is a force majeure event. There is this supervening force. Contrast it with your pre-contractual circumstances and try to then define as to how things have changed. In that context, it also would be relevant for you to see that you are at what stage of performance of your contract. Is it a contract which had just started between the parties? Is a contract where parties were kind of culminating with the objectives? So see at what stage you are. So that's you would be your contractual analysis before you embark on this path of deciding to take recourse under a force majeure provision. Now, as I said that this force majeure is something which has impacted the parties, one or more parties, their ability to perform under the contract, their obligations and liabilities. Now, this impact has a very definite some framework in which you have to consider this impact. Impact is a very subjective term. So law does provide you a certain framework in which you can look at the impact. The first thing that the way a party may be impacted is that it's prevented from performing. That means it's physically and legally impossible to perform this contract in these circumstances. Keep in mind, this is a very high bar for you to establish that it's you are prevented, but yes, the circumstances can be so. The second thing you have to keep in the way in which you may be impacted is that you are hindered in performing. So it's not a prevented, but there is a hindering circumstance, wider in scope and a lower bar, but then the time period steps in. How long were you hindered? So those kind of things will have to be then examined and established. Third way a party could be impacted is that it's delayed in performing. Generally, we find the contracts where sequence and time of performance is specified. People often write the time is the essence of the contract. So there is a contractual performance timeline. So you may be delayed in meeting that timeline. This is the least onerous test. And generally the period of extension of time here becomes the issue. You have to keep in one thing in mind, that there is no need for you to prove or establish or embark on the path to show that you could have performed but for the force majeure event. You need not assume that those kind of onus to try to show that you could have done it had this event not. That's not necessary. The law does not oblige you to do so. Now, now what can you do if you have found a clause and you have established impact? Now you are about to take some steps. First of all, it's a very general concept that the burden of proof of lies on the party who's claiming the force majeure. You have to establish that. Second thing you have to show is that force majeure event was the real and the and the dominant cause of your inability to perform. That means it either prevented you, hindered you, or delayed your performance. So you should be able to link, there should be a causal link between the event and the impact. The third aspect, then you'll have to show that these circumstances which led to non-performance was outside your control. So it was beyond your control to do that. Adjacent to that is also the necessity to show that no reasonable steps could have been taken by you to avoid or mitigate the consequences of the event or its event and its impact on you. So that's your obligation to proceed in this manner. Now, keep in mind one more thing, that your contract does have a force majeure clause, and it does provide you some kind of a procedure. And since you are operating within the four corners of the contract, it's very important to comply with your contractual procedural requirements of the force majeure clause. That means due notification, timely notification, adequate notification and reporting to the other party should be done without any default. In fact, these are in the nature of condition precedents that you notify the other party of the event as well as the impact on your performance. So do follow those procedures very carefully. Now, suppose you have gone ahead and established, claimed force majeure and established its impact as well. Now, what kind of benefits or what kind of options could be available to you in the contractual paradigm? You may be excused in performing your part of the contract, either in whole or part. That means if you establish these circumstances, meet these legal tests, you may be excused. Of course, you can also be excused from delays in performance, and you may be entitled to suspend or claim extension of time for the duration of the intervention. And in the extreme event, you may also have the right to terminate the contract and get out of the contractual relationship. I have also found that commercially, it's also a occasion for parties to sit and see whether they can renegotiate the contract in the changed reality. So do explore the possibility. You can preserve your contract, you can meet your business objective if you are able to renegotiate, redefine the terms which are more realistic and practical in the changed circumstances. Keep in mind that generally force majeure clauses do not extinguish the performance, but it only suspends it. That means it does not kill, it does not kind of completely obliterate the performance, it suspends it for the duration of the force majeure event. That's a feature we find in most of the contracts. So in essence, if you have a credible claim you have established, then it will limit your liability as well as quantum of any potential damages against which can be claimed against. So you have the contract, you proceed, you have claimed force majeure, you have limited your liability and quantum. The last aspect is again is something which is it emerges from the legal paradigm, is that what is not force majeure. We tend to be so focused and at times get drawn into circumstances that we list out various things in our notice or document and start claiming force majeure. It's very important to distinguish and keep in mind as to what cannot and is not a force majeure. First of all, negligence, willful default, malfeasance, all those things, obviously there is no immunity. Also, any usual and natural consequences of the external factors. So if there's something very usual which is there, a natural consequence, it will be held that it was foreseeable by the parties. Then we also find in certain cases circumstances which are specifically contemplated and provided in the contract. Now, if it is so, obviously it cannot go into the basket of force majeure. Merely your performance having become more difficult, onerous, more expensive, or less profitable, these are not the basis or cannot be the basis for claiming force majeure. And obviously, it does not protect you against any previous or antecedent breaches. So that's the position with regard to where a contract has a force majeure clause. Now, coming to the other aspect is that where your contract has no force majeure clause, you are bound to the liabilities and the obligations, but it's not spelled out. Force majeure is, there's no whisper of it. Then our thought would be that you need to do three things. One is look for other clauses of the contract very carefully, because and see the overall construction of the contract. It's not necessary that the clause force majeure is named as such, but you could find certain other provisions which are in the nature of those kind of situations. If you do not find any other clause, then you will have to consider relying on the doctrine of frustration of contract. So we'll talk about it a little later, but then that's an option. And finally, you may rely on the legal principles of limitation of damages. Economic damages in law have certain principles under which you can limit these kind of claims. So you have to then take recourse there. Now, as I mentioned, then in this situation, one of the things that is available to you is frustration of contract. So very briefly, please note that it's a much narrower concept than force majeure. And it is very difficult to establish that a contract is frustrated, because this requires you to show that this unforeseen subsequent event that you control has made the contract impossible to perform. Now, impossibility of performance, we find, is a very, very high legal test. There are various alternate modes of performance, but which can be taken recourse to. So it's a very high legal test. But then if you indeed have to delve in this and take recourse, you will have to then establish this aspect. And when you try to establish frustration, then what you have to ask yourself or try to, and claim and prove is that this event has transformed the performance of the obligation to something so radically different from what parties intended that it would be unfair to hold the parties to the original bargain. That's the test. When you get into it, of course, the duration of the event becomes key, because if there is a limited duration intervention, then it may not lead to frustration. That means you have to see whether your contract is a short-term contract, long-term contract, and what kind of thing. And finally, yes, we do have the Indian Contract Act, which codifies the principle of frustration of contract under Section 56. So there is a legal framework in which you can operate. Now, similarly, there are various things which are not frustrations. As I said, in the case of force majeure, that means contract performance having become onerous, difficult, expensive. All these things are not. So that's my 5 points which we have covered. In the end, I will quickly sum up as to what you as a party or contractual party need to do in these circumstances. Step 1, consider and analyze the force majeure clause very carefully in terms of the framework, rights, and timings. Do explore alternate means of performing, like reducing the delays or minimizing the loss of the other party. As we spoke, follow all contractual notification procedures. Do not rely on grounds like increased costs or difficulties in performance. Those may not help you. Very important, please maintain all contemporary documentary records. This is the evidence which you will need to support your impossibility of performance today. You cannot be tomorrow looking back and trying to create these documents. So please support your contention with records and keep them handy. And of course, if there is no force majeure clause, then consider options under the frustration doctrine. And finally, as I always say, leverage this situation for renegotiation. So Dr. Sirohit, that would be an overall sum up to your question. Thank you.
Thank you, Mr. Ojha, for giving such a detailed explanation to the concept and the idea.
So there is a question from Mr. Sameer Nath. This question is to you, Mr. Ojha. The question is basically, how does force measure affect valuation? I think Rajiv sir can also help you in this question. And the extension of this question is, and on the valuation date, fate of contract based on force measure might not be knowable. Should we consider cash flows from this contract in projected financial information?
Amit,
I think
just I will just introduce one thing and then pass it on to Rajiv ji. The question is mainly for you. I think it's a very valid question and issue today. Two three statement I would like to make. One is that a contract has two very clear phases: execution phase and a performance phase. And of course, by performance, you get discharged of the contract. So one of the modes of discharge is performing the contract. Now, a force majeure let's assume that it has impacted the party's ability to perform the contract. Surely the facts known and knowable at the date of execution, which happened in the past, those don't change. Those, because it was that step of the contract is over. But it is also a fact that if you have made certain assessment, certain projections, certain kind of inputs in valuation based on these contractual rights, you may not get the benefit of those rights as you had contemplated, because the performance stage of the contract stands now impacted by this event. So in that context, yes, there could be implications. Specifically in the valuation principles, how these will translate, I think Mr. Rajiv Singh would be the best person to answer that question. Thank you.
thank you, Rakesh. I think half of the question you have already answered.
There's another question to you, Rakesh sir, from Mr. Vijay Deep Singh. His question is, can one invoke a force majeure clause in a rent agreement, assuming a force majeure clause exists in the rent agreement?
As I had said, that one of the things you'll have to see in a contract is that how does it apportion risks between the parties. Now, if you look at the nature of the contract, a lease agreement, the lessor has already delivered the premises to you at the time of the lease. So there is a possession which has been handed over to you, and you are seated into the premises. You are kind of enjoying, you are entitled to enjoy the premises under the terms of the lease. Now, having performed his part of the contract, it will be untenable for you to then claim force majeure and try to excuse yourself from performing your part of the contract, which is payment of rent and other terms of the contract. So my default answer will be that it will be very difficult for a lessee to take benefit of a force majeure clause, even if it's provided in the contract. Nevertheless, I would say that with only one caveat, that all premises are leased, let out for a purpose. And frequently we find that the purpose is also stated in the contract. If you can establish that the force majeure event was such that it defeated the purpose of the contract, that means you could not use, occupy, or exploit the premises for the purpose that it was given and written in the contract, there is a higher possibility that you may be able to claim the benefit of force majeure. Thank you.
Now, coming back to Mr. Ojha, sir, what is the general impact of COVID-19 on contractual obligations and rights?
Rohi, I think this is a very important question, and I expected that you would ask this, because what I spoke in the first part was a theoretical and explained aspect of force majeure in very generic situations. But now today the world is facing this COVID-19 crisis, and it has to be now seen in the context of this crisis. Now, as I said, that we will, to answer your question, we will reflect the principles of force majeure to this COVID situation and try to see, what best we can assess or what best we can comment. I would like to answer your question in three parts. I would like to just share my screen so that everybody has that. Yeah. Uh, uh, I think the first part would be to, I'll try to see, discuss whether COVID-19 is written 10 there, sorry. 19 is or can it be construed as a force majeure event in itself? Then the next logical question to answer would be, can COVID-19 protect from contractual liability? And the third is that, can COVID-19 lead to frustration of contract? I would like to answer this in these under these 3 points. Now, coming to the first point is that can COVID itself be considered as a force majeure event? We have to keep in mind a certain background facts when we approach this. That COVID-19 is indeed a global happening. It's an event which nobody can deny. Second, we have various national and international institutions who have declared this as a pandemic or an international very relevant adverse event. So various authorities in India, WHO, they have all declared this as a pandemic. So to that extent, the event stands accepted and validated by many credible authorities. Now, including in India, the lockdown which happened because of the COVID. Now, before we go to examine whether COVID could be or is a force majeure event, I would like to put one suggestion here, that we should not look at COVID-19 and its spread and impact in isolation. The force, if you set out to define the force majeure event for COVID, you will have to first look at the event and also the international and national lockdown, which is been declared by various authorities for a very, very significant period of time, and various other measures which have been declared to deal with this event. So, force majeure event for COVID will include this pandemic and also these measures and lockdown and all that. So that's the basket of situation which constitutes the force majeure event, not merely the COVID. Obviously, if you were to examine this in the context of contract, it will first of all depend on your contractual definition of force. How have you defined force majeure in your contract? Well, if your contract and the force majeure clause there includes terms like epidemic, pandemic, then your job is easier, because clearly COVID-19 is accepted, declared, and universally recognized as a pandemic. If your contract does not have these terms like epidemic or pandemic, then it's a question of interpretation of your contract. You'll have to look at the clause and try to deduce what did parties intend to. Try to see whether there are similar circumstances which are provided. Are these exhaustive? Are these illustrative? And what is the interpretation of the contract? Typically, when you find clauses like beyond the control of parties, outside the control of parties, or these things in your definition, then it will be fairly good umbrella for you to interpret COVID-19 under these kind of generic words. But and also prima facie larger meaning is accorded to these phrases in order to reach their intent and purpose. Now, having said that, I would like to believe, and this is what I understand, that generally, in view of the unprecedented nature of COVID-19 outbreak and the actions of the government around the world, it is most likely that it will constitute a force majeure event under many force majeure clauses in various countries. So that's a reasonably safe position to take. But the bad news is that, however, just because it may be so, it does not necessarily mean that a party would be necessarily protected from performing the contractual obligation. You have passed the first test. You have established that this is a force. COVID-19 is a force majeure event. But then, in order to mitigate your contractual risk and liability, you will have to go to the second test, and which was my point number 2 today. That can COVID protect from contractual liability? Now, even if COVID-19 is considered as a force majeure event, which it is most likely would be, the next question to be seen is that what is the real impact on the affected party's ability to perform the obligation? So you have to now take this within the realm of your contract and show how exactly were you impacted on performing your obligations. Now, this is a test which is being used by parties as we talk. The event is only 2 to 3 months old. It's a developing test, and we are looking at it very carefully. But we are seeing that in these kind of claims and cases in the US, in order to escape potential liability because of COVID-19, parties are generally contending three things. A, that it's an unforeseen event. Second, it is outside parties' control, and it has rendered performance impossible or impractical. So these are three tests which are generally emerging. I mean, as we follow, I think this will get much more refined. Now, just to come to the last part, that can COVID lead to frustration of country? That means you are dealing with a situation where you do not have a force majeure clause, and you are faced with this event, and you have to now take recourse under the realm of frustration. Now, when we look at this, it is debatable. It is debatable whether an epidemic or a pandemic would be considered as unforeseen. You remember we had discussed that unforeseen event is one of the first tests of frustration. So it can be, it may not be. We can debate whether this epidemic or pandemic can be on, because there has been previous occasions, and there have been warnings of future as well. But it is conceivable that the extent and duration of the global lockdown enforced by the COVID was unforeseeable. We have not seen this kind of a global lockdown enforced by a pandemic. So this would constitute a very, very strong unforeseeable event. So to that extent, it leads you to the direction of frustration. Surely, if you want to see whether your contract is attracted with the doctrine, you'll have to again go to the contract and see what is the nature of the contract. In cases where time was the essence of the contract, or obligations were strictly time linked, COVID-19 may lead to frustration of the contract because you are unable to perform within the agreed time schedule, and the impact period has extended beyond the performance time frame. So it could lead to frustration more in the situation of short-term contracts than long-term contracts, because in long-term contracts, the duration of the event with the term of the contract leading to a situation where it's impracticable or impossible to perform, that becomes a very, very debatable question. So that to me would be the answer to your question, Dr. Siro. Thank you.
Coming to my next question in this continuation to Mr. Ojha would be to you is, what are the recent judicial approaches to contractual disputes arising during the pandemic period? Do we have any instances?
Dr. Siro, yes, we do have. But these are only, as you said, instances. For it to be called as an approach or a pattern, we'll have to see it over a period of time. From a theoretical perspective, I think it is reasonable to say that in these unprecedented times, courts are likely to be generous and liberal in interpretation of contractual wordings, where parties have genuine difficulties in performing. So you would expect the judiciary courts are very well aware, A, of this event and also the impact it has had by way of global lockdown and those kind of circumstances. So it is in the public domain, the judiciary is not going to disregard it. And with that knowledge, I would imagine that there will be some kind of a sympathy or a generous approach. Still, parties will need legally to show that this non-performance was truly outside their reasonable control and they could not have been prevented or mitigated. So you will have to then go into the contract, list out what the obligation is, reflect in the context of this COVID-19 and actually show that it's outside your reasonable control now to perform and you could not prevent or mitigate. So that's a general overview. We do also have certain instances. We have had certain cases from the High Court of Delhi, including recently, where the nationwide lockdown was held prima facie in the nature of force majeure. So courts have expressed their mind there that this is a force majeure event, and on that basis, they have restrained, injuncted execution of bank guarantees and those kind of commitment documents. So there is a reflection from some of the high courts. We do also have some isolated cases, particularly one from the Mumbai High Court, where the court did not release a paying party from its obligation to make payment under the contract on account of COVID-19. It said that no, you have received, the goods are there, you have to make the payment, more so because that may be in the realm of essential commodities. So that's how it is evolving. As of now, we do not have a very strong case whereby this has been rejected as a claim of force majeure. But then parties are trying to put together the facts and show the impact of the event and accordingly approaching them. I'm sure if we were to visit this topic 6 months from now, there will be much greater jurisprudence on this. Thank you, Dr. Siva.
Okay, sir. Now we understand that in this COVID situation, creating different phases would be advisable and good tool to handle the situation. But can you enlighten us that how we should decide the phases, how many phases, and what can be the likely length of the DCF explicit forecast period?
I think if you go back to from where we started, that was when you were saying different shapes of recovery. So you have to start from, top-down approach. So make a list that whether your company falls under the loser category or is a winner category, because this is a very typical kind of a crisis where not everybody is crying. Somebody is very happy. They want this to happen for a longer period of time because they want to exploit. And one classical example has just come before us. So therefore, it is not as if that everybody is crying. In fact, a lot of people are making money out of this process. So we'll have to see whether you are a winning category or you are a loser category. Within that, you'll have to see that what shape your industry will take place. Within that industry, you can go back and see your company position. You are a dominant player, you are a small player. What is your strength? How much cash you are having in your balance sheet? Can you withstand the problem of liquidity you are going to face? Whether you are labor oriented, who cannot work from home, what kind of a company you are in, you are discussing. All these factors will take into consideration. So your forecast will vary from V shape to Nike shoes or maybe a CAT to U shape. Beyond that, I'm not looking. A W shape or L shape is all afterthought. L shape is not a recovery at all. So with this, it could be 6 months. It could be even less than 6 months, even a quarter. Say FMCG company, IT company, there will be hardly 8, a bank company. So you'll have to go by that. And then in some companies it could be 2 years, some companies could be 3 years. If you are in a hotel business, if you are in a tourism business, if you are in a airline business, then it could be a longer duration. So the first trouble period where we are basically trying to survive is the most critical one. After that you can some recovery period, and then the final phase, or maybe another fourth phase. But having said that, at every state I would try to see that you are not only forecasting profit loss, you are also forecasting balance sheet to ensure that from where the money will come. It should not be a case that you say, oh, I'll achieve this turnover, I'll achieve this and that, but money is not available. If the money is not available for first 6 months, then your liquidity risk gets converted into solvency and you are finished.
So
So
actually, that was my next question. So maybe in L-shaped companies, one should change the premise from going concern to liquidation value.
absolutely right. And what Ojaji also said, if you are a one supplier contract company, if you are or either customer or your supplier, and if it is seriously affected, be careful, because then your company performance will be seriously compromised, and the customer contract has a huge impact. Then you will only get a liquidated value of whatever you can ask for. Because see, force measure and etc., these are all defendable things. But by the time you go in court, Ojaji will confirm me, it takes longer than what we can expect. And by the time my company will be finished. So, so by the time the court gives a judgment, I think my performance, I won't be there in the market to perform. Somebody else will take my place. The market is ruthless. They will not wait for your court judgment and give you a space there. So your market share can be eaten away, and you will not be there to serve in future. Yeah.
Yes, Rajji, that is correct. In fact, the problem could be also more where you are subjected to the jurisdiction of court, general courts, and you go through all those, detailed procedures. In case if there is an option that your contract provides you for international arbitration, maybe
Yeah.
then you can seek a better judicial and a more expeditious judicial remedy. And as we have spoken, that's a topic in itself which we will discuss someday in the current context.
Yeah, absolutely right. Thank you very much for highlighting that part. What he was referring, that some jurisdiction like Singapore or London, if that arbitration is a clause, then it will be quite faster. So that has to be taken into consideration. So this time, believe me, there is a lot of law you need to understand the way it is addressed. If you're a valuer, if you're not comfortable, take help and try to factor into the valuation. Otherwise, you will be making error.